Good evening. Oops, forgot to turn that one off. Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. If we're live and it's not during the middle of the day because there's a trial going on, well, that means it's our Tuesday night Crime Talk. Thanks for joining us. For those of you who have not joined us before, perhaps this is your first time, my name is Scott Reich. I'm a practicing criminal defense attorney here in the great state of Colorado. I've been doing it for 29 years, coming up rapidly on 25 years in private practice. I'd say 95% of my practice is criminal defense. In my firm, we have other attorneys that do other things. I have another attorney that does specifically civil matters, but somehow I seem to always wind up doing those as well. And that's the other 5%. So, excuse me. We do the show every Tuesday night, and kind of a recap of what we've talked about, obviously, so far through the week. And we also take your questions. So if you have a question, put it in the chat there. We'll do our best to check it out and put it up. This is kind of your opportunity to ask me any questions you may like to ask. My first thought is, wow, is it only Tuesday already? It seems like it has been a very busy week. I can tell you in my law practice, it has been very busy. I've kind of Friday, I was in court. I wasn't supposed to be in court. It was one of those days where, hey, you know what? I don't have any court set. I don't think I'm going to wear a tie. You know what? I may not even wear a suit. And then I think to myself, no, the last time I did that, I had to go to court unexpectedly on a new case. And sure enough, the same thing happened on Friday as well. Get a call. Next thing you know, you're in court by 2:00. Do all that. Worked a little bit over the weekend as well. And Monday has just been nonstop, going to various detention centers and jails to see various clients. And that is probably, I don't know if who here has ever been to jail? All right, show of hands. And not in the sense of like you've been arrested, but that's okay. I guess that's included. But if you go to jails, I mean, it's probably one of the least productive, inefficient part of any day is when you have to go to a jail. First, you go there and, you got to get scanned through. You got to go through the security. There's usually someone behind a glass window of some type that, although I do know one location, we don't want to get anybody in trouble, but they're nice. They're actually nice. I'd say 2 locations that I regularly go to. All the others, rude as can possibly be. It's like you're inconveniencing them to come to the jail. I guess we probably are as defense attorneys, what have you. But, you got to talk to your client. Although I prefer to do it on the phone, what can you do? Sometimes you got to go talk to somebody in person. Anyway, it's inefficient. You go there, it's got that certain aroma smell of, once you get in, right? That very distinct clank when they open those big metal doors. You hear them click, and unlocks it. And you go through and it slams behind you. Then you walk to the next door and you have to wait or maybe hit the little button to get to the next door, to go to the right pod, to get into the area where you're supposed to see your client. But it has that weird, funny aroma like fear and baloney with maybe a little bit of, I don't know, just a outhouse, like a porta-john kind of smell. Just has that with a sense of bleach, heavy bleach, because they like to bleach the places. Obviously, when you have people in that kind of close confinement, things can get pretty gross. People can get sick. So they're constantly cleaning. When the tier porters get done, doing the floor or cleaning whatever, they start all over again. Anyway, and then you go to the jail, and it's not like you're in a room normally with, comfortable chairs and what have you. Oftentimes even to this day, you can't take computers in to lots of facilities. unless you get approval to go in, and some will let you do it all the time. Some you have to take it every time. The reality of it is you just got to take paper. It's so much easier. But of course, before you go in, some places are like, oh my gosh, you have just committed a mortal sin. Is that what I think I see there in your file? Well, I didn't want to put any staples in anything. Oh, yes, right. The dreaded paperclip, the arch enemy of any jail. So, of course, you have to show that you've removed all those before you go back to sit in the small room in a little metal chair that's, hasn't been painted in 25, 30 years. The walls, they're scratched up. It's just not fun, and you communicate with the client between a metal screen or a glass door and a little break underneath where you can pass papers through. I've been to some jails where, the pass through was, you couldn't even send a pen through for your client to sign it. So it all just really depends on where you go. But I did a lot of that yesterday, and it's not a fun part of the job. You would think like, oh, I'm going to the jail, man. Like I'm going and I'm getting out. That's even better, right? But it's just kind of a weird, not fun experience. There's just misery and despair in there. Not a lot of happy people. Sometimes you go to some facilities and you're on the same floor and you're like, hey, I need to see so-and-so. Okay. They'll call them out. And you got people transferring from different pods to another. And some look terrified. Others look really comfortable, like they've been here before, in their little jailhouse jumpsuits that they have on. And you're thinking, some of these guys, this may be, other than maybe trial, this may be the last time they wear civilian clothes, but they get 3 meals a day. And then you see how they put them in these little trays, and it doesn't look good, right? And when you get your clients in trial, you ask them, so what was on the menu today? Oh, it was a sack lunch. It was bologna and cheese. Hence the reason why you get that aroma smell of bologna at the jail, because it's everywhere. You cannot disguise it in any way. I don't care how much bleach or Clorox you put on that floor. It is not going to go away. So I know that was a little bit of a digression, but that's what I got to do yesterday. And what's even more fun, all right, to make your day is when you get to a particular facility, because the marshals say, oh yeah, he's going to this location. Hey, that's great. I'll get there bright and early Monday morning and see my client. Good to go. And they're like, yeah, we don't have him. Well, where is he? Because the marshal said he'd be here. Oh yeah, he's not here. Do you know where he may be? Well, we could ask. Could you? That'd be great. Oh yeah, he's at a facility about 3 hours away. How's that going to work out for you? Oh, okay. Well, it's not today. So can we see somebody else that I'm here to, that I can see? Well, so I didn't make a completely useless trip, and then, shoot back to the office, do a quick meeting, do a couple of other things, and then go spend it on a sentencing. And that's how I began my day. I began my day with a sentencing. And it was a good result at the end of the day. I get what the judge did and why he did it. I understand that, when somebody has multiple failures on probation and you pick up an attempted murder case, and even though you're brilliant and handsome, with ruggedly handsome good looks, attorney, I'm just kidding, of course, gets you a sweet deal that makes you probation eligible. Sometimes the judge just can't overlook the facts that, there was a shooting that took place, right? I get that. But with credit time served, 6 months. So it was, I always hate when your client goes to prison. You don't like it. I mean, don't get me wrong. There's a couple of clients you're like, oh yeah. I see ya. Hope you never get out. You're scary. mean, dangerous individual. Bye-bye. Zealously represented you, but bye-bye. See ya. So yeah, it's that was my Monday and that was my Tuesday. And then, tomorrow we're off to federal court yet again. But I like federal court because when you're in federal court, there's usually only one thing on the docket, and it's your case. And that's it. It's not like when you go into a state court and you have 70 different cases all set at the exact same time. So that's good. So, looks like James Bond, 6 months, bearable. Yeah, well, yeah. I mean, on a 6-year sentence, but you get a little bit less, with the earned time, all that good stuff. There should really be some sort of truth in sentencing, but it really doesn't exist. And the reason why numbers are so big on lots of cases is that basically what it boils down to is everybody knows you're not going to serve that much time. And you have to explain that to clients. The reality is jails are full. Prisons are full. Prisons are full. Jails, that's the local county jail. That's where you stay, prior to going to prison. Prison is where you've been convicted of sentencing, unless, of course, you're Richard Allen in Indiana, which is very odd to me. I don't think I've ever seen somebody go off to prison pre-trial like that. But I guess there's some security reasons and what have you. I don't know. But anyway, so we digress a little bit, but hey, a day in the life of Scott Reich, your neighborhood criminal defense attorney. It's always on the go, it seems like. And just when you think you got a break, you have a moment, nothing. Like I was supposed to be in trial this week. Okay. I told you about my week, right? That's it. I was supposed to be in a different state doing a trial. And now here I am. It already filled in. It was amazing. As soon as I knew about Wednesday that it was going to get filled, it gets filled in. So there you go. All right, let's see here. I got a question. Let's see here. Scott, do you think Pryor has an agenda in keeping everyone out of the courtroom by keeping them on the prosecutor's list? Possibly. In most jurisdictions, I think the only place that I've not seen a sequestration order was when we had the trial down there in South Carolina with Alec Murdaugh. And like the witnesses were in the courtroom and then they got in and testified. Like, what? No sequestration order? That was very odd. So let me tell you. So when you have the prosecution has their witness list and the defense has their witness list, the prosecution obviously calls their witnesses, and at the end of it, they ask, are they going to be excused? As you've noticed throughout the trial with Chad Daybell this week, I think every witness, John Pryor said, hey, he's under my subpoena as well, so I may or may not call them back. There were a couple witnesses today that he did not call back. He's like, Judge, these people were on my witness list and under my subpoena, but I am going to ask that they be excused. So at that point, they could then remain in the courtroom. Yes, sometimes you don't. Okay. Jody, I'll answer your question here. Could it be a tactic to keep the people out of the courtroom, other witnesses, things of that nature, so they don't testify? Yes. Okay. And let me tell you, guilty as charged. I have done that before. Okay. If there's some witnesses that are like, well, the witness is young and vulnerable, and we would really like to keep her mom in the courtroom and something along the lines, but mom's also a witness too. So no. And I'm going to keep mama on my witness list, and I'm going to keep her outside of the courtroom as well. Okay. Now there are some exceptions. If you're, a designated family member for the victim advocate, you can sit in there. But for the most part, that's after you testify. I mean, you're still a witness. The general rules apply. You can't do that. If there's a young child, they can ask that a family member be brought in to sit in the courtroom and, cheer them on, so to speak. I get it. I mean, every side does it. Every side plays, little games, so to speak. Do I think Pryor's doing it to keep people out? I don't know. It's also it's a decision where, hey, let's see what these people say on the witness stand. And if something changes, I want to have them at my beck and call under subpoena. Because remember, if you let them go, you can't say, hey, judge, I need to go resubpoena these people. So he's got everybody under subpoena and they're a phone call away, stay within 10 minutes of the courthouse. And, you got to do that. It's a death penalty case. Why wouldn't you do that? So I don't know if there's anything nefarious that Pryor is doing, but, the reality of it is, he's entitled to, and these witnesses, keep him out of the courtroom. I got no problem with that. I really don't. The prosecutors can decide what they want to do as far as their witness list. And if the witness is a family member considered, part of the family, then there's an exception, usually under the rules to do that. But most prosecutors are going to say, why are we going to taint the jury pool, so to speak, with that? So, yeah, I don't see anything nefarious by it, but I know, he could be, but he could also just be zealously representing his client as well. And, yeah. Let's see here. Yes. Okay. Quick question here. Jody, I was wondering how the jury looks at him. It's an empty courtroom. Now, as you may recall, the trial of Lori Vallow that went last year was absolutely, it was packed. Remember, they made such a big deal about it. You had to get tickets. In fact, as I sit here at the CrimeTalk desk behind the CrimeTalk microphone, I have here in my hands the admission ticket to the overflow room of the Lori Vallow trial. For some reason, it wound up right here on the computer, and it has remained there ever since. And I'm sure it'll get top dollar someday. I'm sure of it, in an auction of some kind. But that was it. Yes, this one does not appear to have much attendance at the courthouse. Now, for obvious reasons, as you may recall, the Lori Vallow trial was not live streamed. I think we had audio at the end of the day is all the court was going to do, and we put it up. So if you want to go back and listen to that trial, you can. So there was more reason to actually be at the courthouse, and that was one of the reasons why we did that. Now, we still have several weeks left, and the goal was we were going to what's the word I'm looking for? We were going to try to get out to the Chad Daybell trial, and there's still time. Okay. May is a busy month of traveling, further complicated by the fact that CrimeTalk 1 has been in the shop. It was supposed to be a 2-week ordeal, and now we're going into week 5, and the mechanics keep extending the date and the discrepancy and what have you. And so I'm getting a little frustrated and a little concerned that, will CrimeTalk 1 be able to afford gas at all once the plane is fixed and operational? We'll just have to wait and see, I guess, now, won't we? But anyway, so we've got that. So I was kind of hoping maybe this week we could have gone out there, but CrimeTalk 1 is still broken. I guess we could jump on a plane and go, but and I may have to do this next week for a trip as well. I know, commercial. And then I have to make another trip out to North Carolina as well. So yeah, it's just busy, no doubt. So we'll see, but not a lot of people out there, but I still like to get out there to see it. And although I would still like to talk, get a feel. I doubt the prosecutors are going to talk with us. I'd like to meet John Pryor in person. He's gotten a lot of flack from people. I know some people love him or hate him. Man, I'm telling you, I think he's actually doing a pretty decent job. I really do. Compared to Lori Vallow's attorneys, I mean, I'd give them like about a 3 out of 10. I mean, I'd give Pryor 7, 8. He's doing the best he can with what he's got to work with. And, it's just, he's doing what he can. He's doing what he can. And, he's got his style. The prosecutors, if you're watching them today, they had their style. Pryor knows the rules of evidence. He, knows what he's looking for. And even if he's sustained, well, like today, there was the talk about the officer who responded to the Daybell house after Tammy said that somebody was there with a pellet gun or airsoft gun, I think, or what was not a real firearm, but a paintball gun. Sorry, I don't know what paintball gun. And so the direct examination went off with the police officer just fine. And Pryor just basically is like, hey, your first statement here was on this date, and you said paintball gun. Yeah, yes, I did. And then by the time that somebody in your chain of command, and the guy agreed, like someone in your chain of your command, don't recall who, asked you to revise the report as it relates to the height of this suspect, the description given, and somehow now it possibly included a real gun, not a paintball gun. And, the police officer kind of looked a little silly at times. Well, yeah, I didn't know who told me. And, well, I didn't know it was a gun. I thought it was a paintball gun because that's what she said on the 911 call. But, looking back, we, obviously look for signs of a real firearm. But you didn't find any signs of a real firearm. No, we didn't. And then the prosecutor tried to get up and try to clean it up a little bit. Nobody influenced you, did you? No, but you were asked to change your report. Were you not? Yes, I was. They wanted more detail about it. Okay. You can do that. So it's a, I think he's doing okay. I really, it's been interesting. All right. It's been interesting. And somebody wanted to talk about, I saw it in the comments earlier, and I think they've mentioned it a couple of times. Somebody tried to intervene in the Chad Daybell case early on, and there was some stuff originally about it. And as you may recall, there were other people that tried to intervene previously. It was mostly in the Lori Vallow case. It was the newspaper saying, hey, we want to be able to televise this or, have press in here. And the judge kind of shut everybody down. They were interveners. Then there was the lady writing the book who wanted to be an intervener, and Judge Boyce didn't like her. And all of a sudden, then, there's no basis for anybody to intervene. How dare you do that? But then the Supreme Court's like, well, no, you have to be an intervener into the case because you're intervening since you're not a party to the case, asking for the court to hear what you have to say. The Supreme Court told him that. So Boyce was kind of like, well, okay. Really, there's no reason, no procedural rule to intervene in a criminal case, but I guess the Supreme Court of Idaho says we're going to do that, then that's what we're going to do. So there was a hearing the other day, and originally it started out back in, I guess, end of March. A non-party presented a filing of its motion, even though they spelled the word motion incorrect, to intervene and to continue the trial in these proceedings. So somebody was trying to tell the judge the case of Chad Daybell needs to be continued. And anyway, the counsel for the state and the counsel for the defense were alerted by the court after they received these notifications of service through various the court e-filing system. And apparently this person, when they filed it, also clicked other attorneys that aren't associated with this case in any way whatsoever. And the state and the defense raised concerns about the impropriety to attempt to intervene procedurally and substantively in the case. And the court went on to say that they were going to seal it. There was a hearing the other day about the guy that wanted to intervene. and he got smacked down by the judge as basically being a crackpot clown, and ordered that he pay the attorney's fees for that portion of the day for Chad Daybell's for wasting everybody's time. And the court can do that, sanction somebody to actually pay attorney's fees. It happens more so in civil cases, but a judge can do it if they find that you have wasted people's time, and there's no basis in law, in fact, for this person to intervene in this particular case, and the judge spanked them down appropriately. And it was a guy by the name of Terry Ratliff was the guy's name. That was it. Attempted intervener. And it was the Ratliff Law Office. Let me just see if I can look something up here real quick, see what his thing is. And I think that was when I was in court, law offices, and that was in, so I didn't get to see that portion of the hearing. Yep, has an offices in Idaho. It's kind of weird that they would actually do that. That's, let's see, 23 the James May Terry Ratliff, the trial lawyer of the year. Looks like it's about a 4-attorney law firm. So you think that they would, do something. I don't know what it is. I just don't get it. I've always been a clean shaven guy. And these attorneys, I don't know what it is. They want to have all this facial hair, and they look homeless when they get older and they got all this facial hair. I don't know. It's just me. It's just the way I am. You got to keep this baby face looking good. You start putting all that fuzz on your face like that. Who knows? I don't know. Anyway, this guy has kind of a weird, different little look on his face. Like, I don't know. But hey, that's just me. Anyway, Mr. Ratliff denied his motion to continue. It was unclear exactly who he was doing that with. But let's see here. He was an associate prior, had a conversation with him. When Pryor tried to get off the case, he yelled about it. Let's see here. Let me just put it up here. He's an associate prior in a conversation with him. When Pryor tried to get off the case, he yelled about another attorney that was not given the go-ahead. It very well could have been him. Oh, maybe that was it. Okay. Yeah. I just, I don't know. I mean, it was just weird. Remember, Pryor was basically like, hey, I got to get off the judge. I got to get off the case, judge. I know it's like 3 months before trial. I haven't been paid in years. What am I going to do? Please let me off. And the judge is like, well, gee, I don't know. Pryor's like, I've never even done a death penalty case. I'm not even death penalty qualified, judge. I'm probably per se incompetent. Well, is it about the money? Oh, it's not about the money. You know what? And the kind of, I don't know, questioned his honor, I guess, so to speak. Like, well, if you're going to quit, and I guess I need to do that. I really want this case to move along. And then Pryor's like, you know what? Hell be damned. Full steam ahead, judge. It's not about the money. It's about zealously representing my client. And I can do this. And I'm going to do it all by myself. And, I don't know if it was a little bit of theater on his part to say, look at the big bad government. They have 4, 5, plus all the staff, plus all the police on their side. And it's just little old me, one little guy with Chad Daybell over here, taking notes and marking exhibits in his own damn case. You know what I'm saying? I mean, you got to admit, it's certainly setting up a David and Goliath. Now, is it going to be enough? Wait and see. Tune in every day at 8:30 on CrimeTalk, 8:30 a.m. CrimeTalk. Watch it all develop. Like I said, right now, it's very clear. Lori Vallow, evil person. Everybody knows Lori Vallow, evil. Their defense is humble, devout Christian, Chad Daybell. He was taken in by this Black Widow, Lori Vallow. He had no idea. Alex Cox, Lori Vallow's brother, evil person. Who knows? It may just work, right? We saw it in the George Kelly case down there in Arizona. If you've been following that, we can talk about that for a few minutes. Obviously, George Kelly was the rancher that was accused of killing the Mexican national that was crossing his ranch down there in southern Arizona. And George Kelly believed that he heard gunshots and called the police, said he heard gunshots, etc. And he went out with his AK-47 and, according to him, fired some warning shots. And there was evidence that he had fired the warning shots. And then, of course, the dead guy, Mexican national, they find him and, they think that it's an AK-47 round that goes through, in one side and out the other of the Mexican national. But they never find the actual bullet to see if it's, could be traceable to George Kelly's. They could be traceable to George Kelly's AK-47. Anyway, George Kelly gets charged. He says it was self-defense. And I'm thinking, well, and I'll be honest with you. I mean, I had read about it. I had, kind of followed it, but I hadn't gotten into the specifics of the case until it really got going. And then you start following it and you're like, oh, I see. Everybody's running around saying self-defense, but really the defense was he didn't do it. That he just didn't do it. Not that I killed him, because that's an affirmative defense. It says I did it, but I was justified in doing it. And I was like, well, because that was kind of everybody's pitch. Everybody's claiming self-defense. And then the defense theory is you can't even prove that my guy did it, which is obviously a much better defense. And the prosecution really couldn't counter that other than saying, well, there were bullets at his house and he said he fired, but they were warning shots, but, went up and they couldn't prove it, and they tried to put the little sticks in the, in the body and how they went in, but they couldn't find the bullet, et cetera, never found out there in the desert. And so I remember the George Kelly goes, oh, I don't know, man. Not really self-defense when you're, the same distance as, a football field away, 300 feet, right? 3 feet in a yard, 100 yards, 300 feet, right? Do the math. That's pretty good distance. It's pretty good distance. Kind of not immediate fear, right? I was like, ooh, this could go either way. And then a lot of people are like, well, he's got to do it because of the border crisis. He's got to find him not guilty. This is just ridiculous. He has right to defend his property. He has right to defend his family. And I get that if they're in immediate fear. I was like, the law is not looking good for Mr. Kelly. But his defense attorney, my hat's off to her. She had everybody thinking they're going self-defense. And then her real defense was, didn't do it. Can't prove my guy's bullet killed him. You never found the bullet. You can't test it. You can't prove it. Reasonable doubt. And seven jurors were not guilty. One hangout for guilty. Now, apparently in Arizona, you don't need a 12-person jury for a felony case. Sometimes you can, agree to have less, but why make it any easier for the prosecution is my general advice to clients. But 7-1, they deliberated after the first day. Yeah, we're in an impasse. Jury comes out and tells the judge, been deliberating about 15 hours. Yep, we're done. Can't do it. Or I guess it wasn't that many. It was like 8 hours, I guess. First day. They started, I think, on a Thursday, deliberated on a Friday. Nope, couldn't do it. No, it was earlier than that, wasn't it, Frank? When I'm talking to Frank, the producer, the hardest working man in show business here behind the screen. They started deliberating, what was it, Wednesday of last week or Thursday? Thursday. Okay, so started deliberating Thursday. They said, hey, judge, we're in an impasse. Not going to happen. And the judge says, no, haven't deliberated long enough. gives them the modified Allen instruction, says go back, deliberate, reevaluate your views, but if you're firmly convinced, don't give up on it, etc. All that stuff. Judge says go back and do it, try again. And they come back and do it again. No, impasse, do it again. They finally say, you know what, Friday afternoon. Was it Friday afternoon or Monday, Frank? God, it's all kind of run together. The verdict, the mistrial was it was Monday, yeah. So they go home over the weekend. I'm sure they didn't talk to any of their family members, right? They didn't say, oh man, there's this one juror in there. Total, just making life difficult for everybody. We would have walked that guy out of there in no time. Nope, I'm sure they didn't say that. Anyway, they come back yesterday. We brought it to you live. It was yesterday afternoon. So they did deliberate. So they got Thursday, Friday, had all weekend to think about it, not together, but by themselves. And yesterday, the judge finally declares a mistrial. Now, don't get me wrong. I've had mistrials come back where it's 11-1 guilty. And you're like, okay, the prosecution is going to retry the case. Had them come back where it's been 11-1 not guilty, that one person hanging out. In my experience that I've had is that if it's that overwhelming, prosecution won't go and retry the case. Now, if it's 11-1 for guilty, guess what? You're going to do the case. Little anecdotal side story here. Years and years ago, horrific case, horrific. And it was supposed to be like, I don't know, a 4 to 5 day trial. Not that big a deal. There were a bunch of attorneys, bunch of co-defendants. We're all there. Let's just say you knew almost immediately we had a weak judge and things weren't going to go as planned. We had a very good and aggressive prosecutor, 4 or 5 defense attorneys. It was like no way that we could possibly do this in 5 days, but the judge thought we could do it. Turned out to take 3 weeks. And so we are we're doing this trial, horrible facts, and ultimately gets to the jury and it's hung. And it's like 10-2 or 11-1, doesn't matter, but it's clearly in the favor of the prosecution. And like, oh man, are you serious? Oh my God. All right. So we do it again. And go back, do it again, same trial, blah, blah, blah. It takes a little less time because everybody's been through it once before. Didn't get wrapped around the axle on a bunch of stuff in jury selection. Hangs again. Hangs again. And of course, the whole time I'm moving for severance. And then it was like 10-2 for guilty. Like, are you kidding me? We're going to do this 3 times. Prosecutor's like, let's tee it up. We're going to do this again. Bad dudes, and the joke was basically like, okay, we found 4 of the dumbest people in Denver. Is there a 5th? I mean, that was the question. I mean, even the defense attorneys were surprised that we kept hanging the jury. We're like, all right, we hung the jury. Great. We get to do it again. It's just one of those. And it was just a bad, horrific facts. Don't even want to go into them, but it was not good. It was not good. And ultimately, I do know this, that at some point my client's family actually made bond for him, and he never made it to a 3rd trial. Poof, disappeared. And I remember that was it was just terrible. Bondsman tried to hunt him down. I think it had something to do with that. Let's see, Austin girl. Let's see here. The Mexican consulate is pushing for what he calls justice. They are hell-bent on forcing the state to retry, which is crazy, when it was 71 in a very heavy blue county. Yes, but, sometimes, prosecutors, as you may recall, they're elected, they're appointed, they'd like to keep their appointment. And sometimes things, I know you may find this hard to believe, but sometimes things in the courtroom can get political. I know, who would have thought, right? No way. We're not some little third world country. No way. No, it can. And prosecutors take cases that are in the newspaper of high impact and high importance. And, like I said, that prosecutor thinks they're doing the will of the people when they, are prosecuting cases. They think they're doing God's work. And sometimes, they are. But if, you let political motivation get in the way of what is truly the right thing to do, then that's just wrong. I don't care what party affiliation the prosecuting attorney is. If you're doing it for political reasons, that's just wrong. That's just wrong. So anyway, we got George Kelly. We've got the Cobell, or we've got the Cobell. We got the Daybell trial going on. That'll resume tomorrow morning. We just did a couple of police officers that were at the Tammy Daybell's house. We had the lady and his wife. Why can't I remember her name? Melanie Gibbs testified. Her husband testified. He had a little bit different opinion than Mr. Pryor did. Oh, Mr. Pryor, he's a humble man. He's a gracious man. Well, no, Gibbs' husband was like, yeah, no, he was a manipulator. Yeah, no, he was a manipulator. Truly tried to get people to do things by manipulation. Ooh, sometimes, unless they've said it and you can impeach them on that previous statement, you don't say it. The old thing, don't ask the question you don't know the answer to. I know we've all been there. Sometimes it's worked out beautifully. You don't know the answer, but you ask the question because you're in the moment and you just think, man, I got this. I can do this. And it comes out beautiful. And it's like something you see on TV. It's like it was written, for TV, and it all works out great. And then the other time you start thinking, oh yeah, I got this. Oh, I got this witness. I'm going to get them, and I'm going to put it in there that what really happened was this. And they're like, yeah, no. And well, you can kind of argue with them a little bit, but you don't have it on paper saying they said that, so you can't impeach them with it. Well, don't you recall saying this? No, you can't. So you got to be careful. That's what happened to Mr. Pryor. And then obviously the other big case we've talked about, Bryan Kohberger. All right. I'll be honest with you. I'm not a big fan of Bryan Kohberger. Okay. There's just something about the guy. He rubs me the wrong way. I don't know what it is. I haven't heard him say a word. I don't know the man. Maybe it's just because he's accused of killing 4 people and maybe his DNA was allegedly left behind. Allegedly. Obviously, we will give him the presumption of innocence. And I believe that I have truly been critical of both the defense and the prosecution in the Kohberger case. Specifically, as it relates to the defense, they kept trying to do these, what's the word I'm looking for? They kept filing these motions about the procedural faults as it relates to the grand jury. Now, obviously, we don't have access to everything that Bryan Kohberger's attorneys do. My first thought is, why are you wasting your time on something that never turns out to work out well for anybody? I mean, like 1 in a million shot, so to speak. Let it go. Save it for cross-examination if you think that there was some flaw or faulty procedural due process at the grand jury. Try to work it into the trial some way in cross-examination. So I thought that was a little, whatever. And then, the defense was all like, we need to get to trial. We demand a speedy trial. And I'm like, okay, this is going to be good. Like, he's demanding a 6-month speedy trial. This is great. Like, we're going to have a trial because the prosecution's not ready. And then as soon as the prosecution got like, we are ready. And the judge didn't grant something. And the defense is like, well, now we're just forced to go, we're going to go and have to waive speedy trial. right? And so then instead of that 6 months from they say not guilty, they'll get to it when they get to it, apparently under the Idaho speedy trial statute, right? Okay. Then we've had a couple of issues as it relates to the pleadings, and yes, the whole stargazing alibi. The alibi originally was I was out driving. Now it's like, oh, I always go out and stargaze, and it's a form of relaxation and exercise. And okay, fine. You got an expert witness going to say that? Perfect. Let's do this. Okay. So I've been kind of critical of the defense. Like, hey, if you're going to go, and I really think like, hey, if this was your shot, defense counsel for Bryan Kohberger, Miss Taylor, you're going to say, let's go to trial. You think the trial, even, what was that? Almost a year ago when they said they want a speedy trial. Do you think the prosecution would have been ready to go to trial? Hell no. Hell no. Now, the defense probably wasn't ready either. However, that probably would have been one of their best shots to go at that 6 months and just throw it on all out there. And I, have mentioned this is one of the jobs with the attorney is sometimes you got to have that heart to heart with your client and say, listen, the government is like a big steamroller. Okay. The kind that puts all the asphalt up there and the guy sits up top. It's nice big yellow, got the big metal, heavy rollers on it. And the guy sits up on top of a little umbrella and he drives back and forth and he smooths it out. Right. Those things, if you ever watch them, they don't respond like you're on a Tesla or something taking off from a stoplight when you stomp on it, right? All that torque. No, it's not like that. They're kind of slow. And that's kind of like the government, they're a little slow. Whoomp, whoomp, whoomp. But once that thing gets going, guess what? They can't stop on a dime either. And you don't want to get in front of it once it gets rolling. And so that's why you have to have that kind of heart to heart. Like, here's the deal. Not good for you here, all right? We got some bad stuff. We got some DNA at the house. Maybe there's some evidentiary issues that are also bad for you. But, we can try to do these things, kind of go do our lawyer stuff, and see what happens, right? But I got to know, did you do it? Because if you did, this is our great opportunity to try and do it. If you didn't do it, I guess, we got to think about that, effective assistance of counsel, all that good stuff. But tactically, sometimes that is your best way to go. And like I said, I think and not trying to brag, but I've got on first degree murders, walk people out of the courtroom. I've got 8. Okay. And not to brag, but that's a pretty good number. Okay. I know defense attorneys that have been doing this entire life, never won a first degree murder case. I've got 8. You know what the best chance, everyone, the common thing of all of those? First trial setting. You kind of, maybe delay stuff at the preliminary hearing. Do your investigation. You get to arraignment. You set it for trial. Prosecution never thinks you're going to go to trial on the first trial setting. They just never, ever do. I remember once we had a homicide case, the prosecution dumped all this discovery on us, right before trial. And it's funny because I had a new associate at the time. He was like, oh, we've got to ask for a continuance. There's no way we can do this. I'm like, this is what evenings and weekends are for. And we went through all the discovery, found it had nothing to do with our case. And we showed up at the pretrial conference the next, Monday or whatever it was, and Friday, let's go. We're ready. Prosecutor's like, really? You're not going to seek a continuance because we gave you all that new discovery that we laid on you? Nope. We're ready to go. We've been burning the midnight oil, worked all weekend. We're ready to go, Your Honor. Let's do this thing. Okay. So I always throw that out there on the Kohberger thing. I think probably their best shot was there. Now, once again, I think called down the middle. Hadn't really been impressed with Ann Taylor up until that point. But when they had that hearing about the survey questions, and she put her doctor up on the stand. Dr. What was it? Leland, I think. I got his stuff over here. My Kohberger stack of stuff. Dr. Edelman. Dr. Edelman. She hit it out of the park. They had this hearing, and I think the prosecution was thinking, well, we're just going to have a hearing for a date to get a new date. And Ann Taylor was like, no, I've got my expert right here. We got to move this, Judge. We got to keep moving this along. We got work to do. Okay, put them up on the stand. They were there till I think 6 o'clock that night. I think it was late, wasn't it, Frank? 6 o'clock. And I was like, yep, I would lift my ban on the defense not being able to conduct their survey immediately. The prosecution had nothing. They looked so unprepared. Didn't have any questions, tried to wing it. You could tell the good prosecutor was winging it. And he looked befuddled. And that was the record that was made, was everything with Edelman explained how they did it. The prosecution didn't show up with their expert to say why this rationale was flawed in any way. They haven't supplemented anything in any way, at least not in the public filings, as to why Edelman's processes was flawed. They didn't do that. And so the judge was kind of in a position where he had to issue the order like, okay, I mean, the public record and nobody asked for this to be private. And now those questions are out there. And I guess that stuff was already in the media. And I guess it kind of makes sense. Like Dr. Edelman said, although I'm not going to say his name, Dr. Edelman was right, because then I would admit that I was wrong, and the judge was very adamant. I did not violate his due process rights. You guys responded with an objection saying you wanted to supplement. And he granted it because, oh my God, it was such an outrage. Oh my God, they're asking questions of jurors if they're biased or not. And I was like, I don't think the defense has done anything wrong. I really don't. And turns out the defense was correct on this one. And so was this guy. So, and that's what I'm saying, ladies and gentlemen. You got to call this stuff. Try to call it balls and strikes, right? If they're in the strike zone, like in a baseball game, you call the strike. If they're outside of the house, you're like, man, not only was that a ball, that was terrible. Go back to Little League and play. And that's where you have to be, because every trial is like that. That's one of the things that drives me absolutely bonkers when you watch, news shows and political shows. It doesn't matter how one side has screwed the pooch so bad. They sit there and say, oh, yes, it may look like he has maybe screwed the pooch, but the reality of it is it was the best screwing that we've ever seen. And he's going to really bounce back from this, and it's going to be great, blah, blah, blah. How about you just say, man, screwed the pooch, and you better get his act together, or he is going to get walloped in, whatever the election or debate or anything along those lines. But they just defend it blindly, and you can't do that. And I always get told of being, like, had a shouting contest the other day. Client, well, you're not defending me. What am I paying you for? All you do is tell me bad news. Man, I have to tell you this stuff. You may not want to hear it, but it's my job to tell you how this looks. What does this mean? And everybody thinks there's going to be a magic motion to make everything go away. It simply doesn't happen that way. So, and that's the job. I mean, like I said, you have to call balls and strikes. If as me as an attorney, if I went in there every day saying, oh my God, Scott, you are absolutely the best attorney every day, that'd be silly, right? I mean, I have walked out of a courtroom thinking, oh my God, I must be the worst attorney ever. My client just got 300 years, as you're walking out and everybody's looking at you, you're like, business card, please. Business card. Best attorney ever. Hire me. Get you 300 years. Now, obviously, I didn't get him 300 years. The client's conduct got him 300 years. But, every day you have to look at, okay, what did we do and how can we do better? And just like we try to do on CrimeTalk, but, we try to call balls and strikes. Heck, what was it? The Richard Allen case. I mean, Judge Siegel, I think she has messed this entire case up so bad. But I also think that the motion to suppress the statements of Richard Allen allegedly made while in custody in the Delphi case, it doesn't have a shot in hell to be granted. And we call it like that because I think that is truly what the circumstances are. I get the defense in the Richard Allen case is doing what they have to do. But if your client's going crazy, allegedly in the cell and blurting out, I killed Abby and Libby, not in response to any questioning that was made to entice or elicit an incriminating response, that's just an admission by a party opponent, and it's coming in. And I get you got to try to make that record and say, oh, there was psychological coercion, the government action, and this and that and everything else. But I don't think that motion is going to fly. And so that's why I said, I don't think that motion is going to fly. It was in today's show, we talked about it. So I just, it's just, you try to be as intellectually honest as you can. And that's what the law is supposed to be. You are supposed to be intellectually honest, applying the facts to the law, not just, well, that's my racehorse, and I don't care what that racehorse does. The other side is wrong, and he's guilty, and that's it. I mean, if you can't say, hey, the guy scored a good, the other side scored a couple of points today. They did good, right? You got to be intellectually honest. And I know there are lots of channels you can go to that they'll tell you whatever you want to hear. Oh, here's the Bryan Kohberger is so guilty channel. Let's just talk about how guilty he is. Yeah, he's guilty. And I don't know if he is or not. I think he's got a couple of bad facts. Let's be realistic, right? Heck, I wouldn't be a good attorney if I sat there and said, oh, Bryan Kohberger has gonna win easily a trial. That'd be a crock of garbage, right? He's got to overcome that DNA. I mean, let's just face it. And don't get me wrong. And maybe I'll do a show on this here real soon. Show you the breakdown of the various levels of the quality of the DNA. And it's not as clean and clear as everybody would like to think. There's a lot of fudging of the numbers when it comes to DNA evidence. Heck, we have a case here where the chief lab analyst who had been doing the jobs of the Colorado Bureau investigation for 28 years, ladies and gentlemen. She worked on some of the biggest cases that ever hit the state. She fudged her numbers. And the legislature has said, by the request of the district attorney's council, all the DAs in the state, hey, legislature, we need $7 million because we're probably going to have to retry up to a few hundred of the cases that this analyst put her hands on and testified to under oath, knowing that the numbers were fudged. Right? So always be hesitant of DNA. Now, I'm not showing or saying that Bryan Kohberger doesn't have some problems. He's got some problems. And I don't know if they have a knife, a K-bar knife, right? Because only on CrimeTalk would your lovable host have a K-bar. And not only just any K-bar, the K-bar that he got when he was a young enlisted lad in the United States Marine Corps back in 1988, ladies and gentlemen. Still have it. And when this Kohberger case came out, I had to go and find it in a duffel bag of old Marine Corps uniform stuff. So anyway, and I don't know if they have him purchasing a knife. I don't think he'd be that dumb, but maybe he is. I don't know. But this little itty bitty little, see that little thing, that you snap it there, you snap it and where it comes out, right? And I must say, this K-bar, horrible knife, horrible knife. Okay. Terrible to sharpen. Maybe if you're out in the woods and you got to go do your thing to dig a little hole, maybe that's about what it's good for. This one is probably so dull. I'm not sure I could even cut it. Could we cut? No, we don't want to cut the Lori Vallow sticker though, do we? Let's see. We have a sticky here. Will it even cut this? Barely. Okay. This one's not so sharp. So not the best knife, to be honest with you. Not the best knife. But it was kind of a Marine Corps thing. Everybody had to have a K-bar. It goes back to World War II, all that good stuff. Anyway, what other host would just happen to have a K-bar sitting around to bring it in and explain to you how that little DNA got on that little itty bitty button right there? Well, more than likely, if you touched it and pushed it, because it is a little difficult to snap. And this one is, 30 some odd years old? And look at the leather. It's kind of soft and broken up. When you get it, they're hard. And the button is even stiffer, which would mean you'd probably have to push on it harder to do that, which would obviously potentially transfer sweat oils from the person, which could leave the DNA on the knife sheath that just happened to be underneath the victim. Now, of course, you can argue transfer and all those other different things, right? But unless you can explain it away or explain that the process or for the testing of it or the collection of it or the analysis of it was flawed, you got to be able to explain it away. Having tried many a DNA case over the years, juries pretty much believe DNA. They don't really care if it was low-level DNA. And sure, if it got just like 2 points lower on that schedule, it wouldn't even be, you could say, a high probability, the hypothesis that there's a 1 in 800, there's a likelihood that it's that person's DNA, but it's close enough for us because it's DNA. DNA. We see it on the crime shows all the time. So it must be true. So anyway, that's where that is. But like I said, you know what? Only CrimeTalk can you get in-depth legal analysis and happen to have as a demonstrative aid a K-bar. And not just one that he went out and bought for this. Nope. He's had it shortly after he got out of boot camp in 1988, ladies and gentlemen. Had that bad boy strapped to my H harness right there for many, many, many years. So anyway, so Kohberger, like any of these cases, you just got to call it the way it is. I thought there were problems with the Kelly case. I'm like, self-defense? I mean, that's what everybody keeps saying, self-defense. And the defense, I don't know if it came to him halfway through the trial. I doubt it. I mean, the prosecution knew about it because the expert disclosures were like, hey, you can't prove who did it. The bullet wasn't him, so you can't prove that he shot him. Genius. And if that was a predominantly blue county, because there were so many people in that George Kelly case, once again, political or not, I don't know. But a lot of people were picking sides because, well, we should be allowed to protect our country, his property. I get all that. But unfortunately, that's not what the law says. You can't really use deadly force to protect property. I think the world would be probably a lot safer place if you could use deadly force to defend your property. A lot of less people would be willing to take your stuff, particularly if they thought that there was a chance of death or serious bodily injury. But that's not the law. So that's what I was like, hey, I mean, I'm kind of like George Kelly. I get it. You want to protect your property. It's your property. Why are these people crossing your property? They're always crossing your property. They're scaring your family. They're scaring your wife. I get it. You want to defend your property. I get it. But, as I was telling, somebody the other day, man, I'm not some policy wonk down at the legislature telling people what the law should be. And this is the way it is. Like, I am down in the weeds every day in the trenches, trial attorney. And I have to tell you what the law is right now, not what it should be, what I think it would be better if it were, but I'm not king. I'm not king for a day. I can't change the law with a snap of my fingers and say, this is what it is. So I have to be able to do, I have to be able to tell you what the facts are as it relates to that. Super chat, Franks tells me. So we always appreciate super chats. We don't ask for them, but we appreciate them. And it, as you notice, it certainly makes it easier to see the question right there. Scott, are you going to be covering the Karen Reed trial?
Working on it.
They're working on it. We're working on it. 19 jurors have been seated as of Monday afternoon in the trial of Karen Reed, the Massachusetts woman who was accused in the 2022 death of her Boston police officer boyfriend. Apparently they had some jury panel issues the other day. The defense wants 20 potential jurors so that 4 can be dismissed, and they hope that they have jury selection done by tomorrow. They wanted 16 plus 4 alternates in addition to the 12 who will be sent in deliberations. The constitutionality of the courtroom concerning the seating arrangement for a 16-member jury. They're arguing the current layout of the Norfolk County Superior Courtroom would violate her constitutional right to confrontation because several members of the jury will be unable to see the faces of witnesses. They argue this opportunity for observation is protected in the United States and the Massachusetts Declaration of Rights. I would have to agree with the defense. The jurors and even potential jurors have to be able to see the witnesses. You have to be able to judge the abilities, the witness's ability to recall, recollection, and strength of memory on the stand, and how they handle being subjected to cross-examination. So yeah, I have to agree with that. It looks like you need to get a bigger courtroom or figure something out, Judge, but you can't have the other people sitting in the other courtroom. Figure it out is what I would say. And I just saw a slip opinion today on a case. It was a Colorado case, but interesting nonetheless. Now it was in the COVID era. Now remember how I always say, you can't close the courtroom. It's a public courtroom. Anybody can come in and watch, and you can't do that. You can't kick everybody out. Even if your jurors are too big, better go do your jury selection in a bigger courtroom, anything along those lines. Anyway, this was during COVID, and the judge didn't live stream the trial, and he live streamed it to another courtroom where people could sit, but the defendant was there all by himself. The guy was pro se. He was like, shouldn't my people be able to come in here and watch the proceedings? Well, needless to say, the defendant was promptly convicted by a jury of his peers, and the Court of Appeals said, you can't do that. You close the courtroom. You have a constitutional right. Any defendant has a constitutional right to a public trial, which means you can't close it, even if it's being live streamed in the courtroom next door. Guy gets a new trial. So, it may seem silly at the time, but the United States Constitution, ladies and gentlemen. And so if you love true crime, you have to love the Constitution. You have to embrace it, because those are the rules that dictate the courtroom. They really are. Dictates the law, right? 4th, 5th, 6th, Eighth Amendment, those are the big ones. But all those little things, right to confrontation clause, right to, see and present evidence, subpoena witnesses, Sixth Amendment. Public trial, Sixth Amendment. Effective assistance of counsel, Sixth Amendment. Due process. Hey, you can't do that, Judge. We need to have due process. Got to be fair. Both sides get to respond. It's got to be fair. It's not just stuff that people have come up with over the years. They wrote it down in the United States Constitution. No one had ever done anything like that before. Not many have done it since, where it's lasted. We've done pretty good. And what is it? I think there's a book. What is it titled? You've Got Yourself a Republic If You Can Keep It. Great title, right? I mean, we have a constitutional republic. We're not supposed to have stuff coming out of central planning like they did in Moscow. Oh, Moscow. Oh, they said we're going to build X number of cars and we can have this number of food. And no, we're a republic. We're a constitutional republic. We're not a democracy. I hate it when they say we're protecting democracy. No, we're not. It's a constitutional republic, ladies and gentlemen. We have a representative form of government, a Republican form of government, and not like the political party Republican form of government. Republican form of government that you send representatives to supposedly do the work of their constituents. Now, we all know that really doesn't happen. But anyway, we'll leave it at that. So if you love true crime, you got to love the Constitution, because what do we say? The Constitution matters. It does, ladies and gentlemen. It does. And it's not just when it affects you. I'm telling you, you got to protect everybody's constitutional rights, because otherwise they'll come for all of them. And I mean, they come, it'll be the people in power. That's what they do. Okay. Nobody in the government gets up and says, you know what? I think these people need a little more freedom. I think they can handle the truth. I think they should be able to see all courtroom proceedings at any time they want. No, we can't do that, because then they'll see that we're just ordinary people making this sausage in here, and they could think anybody could do it. And we have to let them know that, well, we're attorneys and judges, and we have to be secretive and special because we've gone to law school and pulled the ladder up now that we're on board, and don't let anybody else in. Let's talk in big fancy words and use Latin. No, let's keep it simple. Let's have it so that everybody can see what's going on at any time and see if the process works. Love it. Love it. Love it. Love it. Okay, ladies and gentlemen, can you believe we've been already going over an hour and 10 minutes? We always try to cap this about an hour, and we always go over because you guys are great. You're great. I'm still one of these days, we're going to have to do another call-in show as well. But if you want to do the call-in show and you're like, God, Scott, I'd really love to chat with you and see what you have to think about this particular subject, well, you can do that next, because we're going to be switching over to our Patreon show. The little link is down below. And if you become a Patreon, I think it's like $1 or $2 a month or something like that, $5. Well, you have your own private show, and you can ask me anything you want, and you get to call in, and we do the Magic 8 Ball. That's right. Collectively as a group, we try to come up with a question for the Magic 8 Ball. We take suggestions, but I will make the final decision ultimately and ask the Magic 8 Ball questions. Just to give you a teaser, let's see here. Will the prosecution go forward on Monday in re-prosecuting George Kelly? Oh, the Magic 8 Ball says signs point to yes. And then, of course, we have to see if the Magic 8 Ball is correct, right? I'll be honest with you, I can't really remember what we did last week, but it's always fun. So come join us. Come be a Patreon. All right. Want to thank you all for joining us. We do appreciate you being here. We know there are lots of other things that you could be doing with your time. So the fact that you choose to spend it with me is very humbling, and I am very appreciative of you. Thanks for watching. Have a wonderful night. We'll see you next time on Crime Talk. And yes, remember, the Constitution matters.